Anyway, SNAP benefits. Regardless of how you feel about how much money poor people should receive or whatever this and that, SNAP benefits are something a lot of people depend on. You can't just take it away without a plan. So the fact that SNAP benefits have been cut off for the nation and every state is left to fend for itself. Pennsylvania, for example, Josh Shapiro has authorized $5 million in executive funds that he was, quote, able to move around, something like that, for food benefits or food relief, money to go to food relief at food shelter, at food pantries. He's not able to allocate more, if I have this correct, because there is still not a budget in Pennsylvania and not agreement in the state Congress. So 2 million Pennsylvanians are currently not receiving their food stamp benefits, which, if you're not familiar, is in the form of a kind of debit card that works at grocery stores, and you can only buy certain categories of goods. For example, I think one of the debates that's always ongoing is whether or not you can use it to buy a hot meal. Because if you're on food stamps, shouldn't you be saving money? So why buy a prepared meal when you could instead buy something less expensive? It's a debate. Maybe the prepared meal is made with healthier ingredients. I don't know. You can have this debate all day. That's not what we're here for. What we're here for is that it's been suddenly cut off and it has now encountered the legal system. So let me bring this up here. This is only 15 pages long. You're not going to be here forever. But I want you to see what the judge said, Judge Talwani in the Commonwealth of Massachusetts et al., which means a bunch of other plaintiffs, against the USDA et al., which includes, I believe, the Trump administration or whatever parties can get SNAP benefits done. Pending before the court is plaintiff's motion for a temporary restraining order seeking to enjoin, on an emergency basis, defendant's November 1st suspension of benefits under the Supplemental Nutrition Assistance Program known as SNAP. For the reasons stated below, plaintiffs have standing to bring this action and are likely to succeed on their claim that defendant's suspension of SNAP benefits is unlawful. Where that suspension of benefits rested on an erroneous construction of the relevant statutory provisions, the court will allow defendants to consider whether they will authorize at least reduced SNAP benefits for November and report back to the court no later than Monday, November 3rd. Background. In 1964, Congress established the food stamp program, now known as the Supplemental Nutrition Assistance Program, SNAP, to serve as a supplemental nutrition program to permit low-income households to obtain a more nutritious diet through normal channels of trade by increasing food purchasing power for all eligible households who apply for participation. Participation in SNAP is generally limited to households whose income is at or below 130% of the federal poverty line. 41 million people participated in SNAP in 2024. Let's do some math. I have a calculator here. I don't think you can see it, but whatever. That's okay. You'll have to trust my math. So, how many people are in the U.S.? Is it 340 million people now? 342,700,000. Let's say 343 million. So if you have 343 million and 41 million are on food stamp benefits, that is 12% of the population. That is 12 of 100 people, 6 of 50 people, 3 of 25 people, 1 of every 8.3333 people that you just cut off of money for food while raising their health insurance, because everyone's applying for health insurance now, right? Yeah, I am not happy, hence no hat. What's the other statistic? 130% of the federal poverty line. Federal poverty, not the pottery line, 2025. Federal poverty guidelines. Let's see, household of 4, would we say 130%? So if a household of 4 makes less than $41,795 a year, if a household of 1 makes less than $20,345 a year, not a lot of money in 2025. Congress appropriates funds for food SNAP benefits each fiscal year. The annual appropriation consists mostly of one-year base funds and sets aside a portion of the appropriation as a 3-year money for contingency fund. I'm not entirely sure what that word salad means. The USDA administers SNAP at the federal level, but relies on state agencies to implement SNAP locally by processing applications, certifying eligible households, and calculating the amount of benefits for each household in accordance with applicable laws and guidance. SNAP requires approximately $8.6 billion of funding per month, of which roughly 8.2 funds SNAP benefits directly, and $450 million covers associated administrative expenses. Let's do that math just for fun. If you have $8.2 billion, not 802, $8.2 billion and $8.6 billion, that's 95% efficiency and approximately 5% overhead. That sounds normal. That does not sound like someone is stealing your money. Of course, where does the money go? The people who need food assistance pay for their food with these benefits, and the grocery stores get the money, and therefore the grocery stores buy from their suppliers. So there's an entire economic chain here, there's an entire supply chain here that is also going to get interrupted. So just let's pretend for a moment that a person wasn't sympathetic enough with people who are going hungry, and instead you're more sympathetic or also sympathetic with businesses who are going to lose money and farmers who are going to lose value of produce. I don't know if it will be catastrophic, but it will be a 12% shift at least. It's a big deal. It's a suddenly overnight not make 12%, especially during the holiday season. This is really rubbing me the wrong way. So I'll try to keep focused here, but you get where I'm coming from. The underlying mechanics through which SNAP benefits are distributed involves parties at the federal, state, and individual vendor and retailer levels. As between USDA and the states, the USDA makes funds available to the states via letters of credit that are updated daily. Each month, state agencies prepare benefit issuance files that contain SNAP recipients' benefit amounts. The agencies then send these files to third-party vendors who in turn load the appropriate benefit amount onto recipients' EBT, electronic benefit transfer cards. Recipients are then able to use their EBT cards for food purchases at licensed SNAP retailers. Retailers are paid each day by the third-party vendors for all SNAP transactions. Vendors then reimburse themselves by withdrawing funds from state USDA-funded letters of credit. States typically stagger the issuance of SNAP benefits to households throughout the month. States commonly stagger issuance dates through the first 3 to 20 days of the month, in part to avoid having too many low-income households going to the same food stores all at once. Not a bad idea. Maybe that will mitigate this a little bit. I don't know. That people weren't expecting their money on the first. You can tell me what your experience is. And I'm serious. This is a two-way street. I want to know what your experience with this is. If you know of food scarcity in your area or somewhere, let me know, and we will do what we can about it. Bring attention to it. Donate some money, whatever we can. Under the Food and Nutrition Act of 2008, assistance under SNAP shall be furnished to all eligible households who make application for such participation. SNAP is subject to the availability of funds appropriated under the law, which provides in part that in any fiscal year the Secretary shall limit the value of those allotments issued to an amount not in excess of the appropriation for each fiscal year. Through the Appropriations Act, in addition to appropriating regular funds, Congress appropriated $6 billion to SNAP through September 30th of 2026 to be placed in reserve for use only in such amounts and at such times as may become necessary to carry out program operations. This is critical. Funds have been appropriated. Congress has given the executive something to execute. Because Congress did not pass a regular appropriations bill for fiscal year 2026, SNAP's funding lapsed on October 1st, 2025. In anticipation of a potential lapse, USDA published a lapse in funding plan on September 30th, in which it affirmed that SNAP operations should continue in the event of a government shutdown, and that multi-year contingency funds previously appropriated by Congress could be used to fund SNAP benefits if needed. On October 1st, USDA sent a letter to the states affirming that USDA would continue to fund benefits due in October 2025 and continue to administer the program in accordance with the law. On October 10th, USDA sent a second letter to the state's SNAP agencies in which they warned that if the current lapse in appropriation continues, there will be insufficient funds to pay full November SNAP benefits for approximately 42 million individuals across the nation. USDA therefore directed states to hold their November issuance files and delay transmission to state EBT vendors until further notice. On October 24th, USDA sent a third letter in which the agency announced it will suspend all November benefit allotments until such time time as sufficient funding is provided or until the Federal Nutrition Service directs states otherwise. The letter directed states to take immediate action to implement this suspension. The USDA circulated a memorandum to the states on October 24th asserting that the contingency fund could not be used for November 2025 benefits. Again, asserting that the contingency fund could not be used. According to the agency, the contingency fund is not available for fiscal year 2026 because the appropriation for regular benefits no longer exists. October 28th, plaintiffs filed this action, alleging, among other things, that the USDA's suspension of SNAP funding for 2025 is contrary to law, arbitrary and capricious, and an abuse of discretion. Plaintiffs filed a temporary restraining order motion seeking to enjoin the suspension of SNAP benefits. The court held a hearing on October 30th. I'm going to skip over standing, but it is a very important part of the law, so to not completely skip over it, a person must have a case or controversy, and that case or controversy requirement includes that an injury must be concrete, particularized, actual, or imminent, fairly traceable to the challenged action, and redressable by a favorable ruling. That's how you get jurisdiction at the basic level. There's still more to it, but standing is one of the jurisdiction requirements. The issuance of a preliminary injunction before a trial on the merits can be held is an extraordinary remedy that shall only enter if a plaintiff makes a clear showing of entitlement to such relief. We consider 4 factors: the likelihood of success on the merits, so a little bit of a trial right now; the potential for irreparable harm, so damages that aren't redressable by money or by a later order to shift ownership or title or something like that. 3, the balance of relevant impositions, the hardship to the non-movement if enjoined as contrasted with the hardship to the movement if no injunction issues. And 4, the effect of the court's ruling on any public interest. When seeking relief, the harm must be likely, not just possible. The first factor is the most important, the demonstration of a likelihood of success on the merits. A strong likelihood must be established that plaintiffs will ultimately prevail. Here, plaintiffs have demonstrated a strong likelihood of success on the merits. The defendant's suspension of SNAP benefits is contrary to law. At core, defendants' conclusion that the USDA is statutorily prohibited from funding SNAP. Defendants are the government, remember? The defendants, the government, concluded that they can't fund SNAP benefits because such funding is contrary to law. To the contrary, defendants are instead statutorily mandated to use the previously appropriated SNAP contingency reserve when necessary, and also have discretion to use other previously appropriated funds as detailed below. When Congress established the program in 1964, it did so in part to utilize the nation's food supply to the maximum extent practicable to safeguard the health and well-being of the nation's population and raise levels of nutrition among low-income households. Pursuant to the Food and Nutrition Act of 2008, assistance shall be furnished to all eligible households, that word is shall, subject to the availability of appropriated funds. Okay, so they didn't appropriate funds, right? Plaintiffs correctly assert, and defendants do not dispute, that the USDA's provision of SNAP benefits, which shall be furnished to all eligible households, is mandatory under the Food and Nutrition Act. As both parties acknowledge, Congress has not yet appropriated any new funds for SNAP benefits for fiscal year 2026. But Congress took steps to protect against the deprivation of SNAP assistance. Congress separately appropriated $6 billion to the SNAP program to remain available through September 30th, 2026, and be placed in reserve for use only in such amounts and at such times as may become necessary to carry out program operations. As plaintiffs point out, given the mandatory nature of SNAP benefits under the law, and the appropriation of these funds to be available through this current fiscal year, the government is obligated to use this contingent reserve account to fund SNAP as may become necessary to carry out program operations. I cannot stress enough that this is an executive branch function to execute the law. The Constitution that the executive, POTUS, Trump, took an oath to uphold, the Constitution says he shall faithfully execute the laws. If you don't see this as being a faithful execution of the law, you're probably right. You're with me at least. I don't see this as a faithful execution of the law. Do you? Defendants, government, Trump, argues that because there is no money available, then there is no annual program allotment and therefore no funds. Stated differently, the use of the separately appropriated contingent reserve to fund SNAP benefits is somehow predicated or contingent or conditional on Congress's annual appropriation of funds to the SNAP program. Congress has placed no such restrictions on the 2024 Appropriations Act. Defendants contend further that these reserve funds are not sufficient to fully fund the SNAP program for the month of November. Even if that is so, the statutory scheme does not contemplate an outright suspension of the program while some funds are available. Instead, Congress directed that if appropriations are deficient, the Secretary shall direct state agencies to reduce the amount of such coupons to be issued to participating households to the extent necessary so as not to exceed the available appropriated funds. And the current statutory scheme contemplates a reduction in benefits as opposed to a suspension or cancellation in response to deficient appropriation. Defendants argue that a suspension is permitted under the USDA's regulation and that USDA has consistently interpreted its authority to allow for the suspension or cancellation of benefits when necessary. The regulation at issue, listed here, 7 CFR 271.7a, sets forth procedures to be followed if monthly SNAP benefit allowances must be reduced, suspended, or canceled to comply with the law. But that the regulation allows for a suspension when there are no funds does not mean that defendants may choose a suspension over a reduction while funds do remain. If the regulation did authorize such discretion, it would be inconsistent with the statutory mandate that benefits shall be paid unless funding is no longer available. Moreover, defendants fail to address the import of the law's highly detailed step-by-step procedure with which to effect a reduction. There's a reduction method and calculation percentage, a notification process, computer program and card system adjustments, proper rounding of benefits, and distribution of issuance tables. Nor do defendants address USDA's view at the time of rulemaking in 1981 that when funding is insufficient to provide full benefits, the agency is required to reduce the value of benefits to those households rather than cancel it. Finally, the court notes that any reliance on the regulation to support the suspension of benefits while appropriated funds remain available has not previously been tested, as there has never been a suspension of benefits during the program's 60-year history. There has never been a suspension of benefits during the program's 60-year history. With this statutory and regulatory context, plaintiffs are likely to succeed on their claim that Congress intended the funding of SNAP benefits, even if at a reduced rate when appropriated funds are insufficient. Here, Congress appropriated $6 billion to SNAP. Remember, we said it was 8.6 or something like that per month. So there are funds, it's not a full month, but there are funds to be used in such amounts and such times as may become necessary to carry out program operations. Where there are, at present, no new appropriations, this contingency reserve is appropriated for use when funding necessary operations, and it is available to the USDA and must be deployed. So the judge is saying that they must deploy the SNAP benefits. I do understand that as of the making of this video, Sunday the 2nd in the afternoon, that's not, it's your morning, that the benefits have not been paid. But then again, I'm not sure if they're all paid at the same time. It sounds like they're distributed around the month, throughout the month. So maybe some families, many families maybe the majority of families, aren't currently experiencing a food crisis, but will be shortly. As a matter of law, defendants erred in concluding that the USDA is statutorily prohibited from using the contingency reserve to fund SNAP benefits. Plaintiffs are therefore likely to succeed on the merits of their claim, and the suspension of SNAP benefits is contrary to law. Footnote 3 here, the USDA concurred with this interpretation of the law. Congressional intent is evident that SNAP operations should continue since the program has been provided with multi-year contingency funds that could be used for state administrative expenses to ensure that the state can also continue operations during a federal government shutdown. These multi-year contingency funds are also available to fund participant benefits in the event that a lapse occurs in the middle of a fiscal year. To fulfill this congressional intent, it is necessary that a limited number of FNS employees be accepted from furlough to support program operations. So they changed their mind sometime in the last month. This is September, and now all of a sudden it's a different tune, moving the goalposts. Moreover, as plaintiffs note, in addition to the contingency fund, there are additional funds that defendants would have discretion to access. The Agricultural Adjustment Act of 1935 allows, Congress has set forth a mandatory permanent appropriation that stems from 30% of customs receipts receipts on all imports from the previous calendar year, not this one. Much of this funding is appropriated for the child nutrition program, but USDA has authority to authorize funds for to authorize funds transfers discretionarily. The USDA has done so recently to the WIC program, which is for pregnant women, I believe. Defendant may also consider relying on these discretionary funds to fund the remaining SNAP shortfall. Irreparable harm. At present, SNAP funding will not be available on November 1st. This suspension will not immediately impact all recipients, as SNAP disbursements may be staggered throughout the month. The USDA's letter, does not indicate that it would be possible for benefits to be issued retroactively. At least some recipients will not receive SNAP payments at the beginning of the month, and this absence of SNAP payments will undoubtedly result in substantial harm to them. But as to the plaintiffs, irreparable harm may still be avoided. Defendant's suspension of the SNAP payments was based on the erroneous conclusion that the contingency funds could not be used. The court has now clarified that defendants are required to use those contingency funds as necessary for the SNAP program. And while these contingency funds reportedly are insufficient to cover the entire cost of SNAP for November, defendants also may supplement the contingency funds by authorizing a transfer of additional funds pursuant to the Agricultural Act 7 U.S.C. 2257 to avoid any reductions. Whether defendants choose to use only the appropriated contingency funds, etc., defendants now have different options before them. Where defendants may now opt to provide full funding from previously appropriated funds, plaintiffs have not yet demonstrated a full risk of reparable harm. The motion for a temporary restraining order, therefore, remains under advisement. No later than Monday, November 3rd, defendants shall advise the court whether they will authorize at least reduced SNAP benefits for November, and if so, their timeline for determining whether to authorize only reduced SNAP benefits using the contingency funds or other funds, etc. United States District Judge Indira Talwani, October 31st, 2025. And it's my understanding that the benefits have not been paid yet. I'm happy to hear from anyone in my audience that knows from experience, either firsthand, or if you know anyone who is experiencing any food scarcity because of this situation yet. Hank Green has sent up the red flag. People will need to donate to their local food banks time and money and food. If I understand correctly, if I got my statistics from Hank Green correctly, the number of people on food assistance, for example, in Pennsylvania, is 2 million people. I think the court order said something like it was 41 million people total on food assistance. SNAP benefits provide most of the food resources, food pantries, food kitchens, soup kitchens, that kind of thing, like homeless shelters, that kind of thing. They provide 1/9, basically an order of magnitude fewer resources. So when SNAP just ends and 8/9 of 41 million people need food, they're going to go to their local food pantry and find that it's not set up for providing 9 times the number of meals that it's been providing. So if this problem goes on for very long at all, there's going to be a lot of unnecessary suffering. And I don't normally get preachy. I guess sometimes I get preachy, but I'm going to really get preachy here. I was raised Republican conservative. I was raised as a loaves and fishes Christian. You don't do this. This is not a Christian thing to do. This is not a humane thing to do. This is downright evil. This is downright mean. And I am ashamed that my immediate family voted for this. I am deeply, deeply ashamed that my family, my immediate family, and much of my extended family went full MAGA with no reasoning, no arguing, no debating, no, wait, let me bring you back to reality. Gone. And it goes against everything that I was raised to be. I now consider myself an atheist, but I keep many of the morals that I learned from my youth, including that you do not let your neighbor go hungry. Sorry, this is a big one for me. You don't look in your neighbor's bowl to see if they have more than you. You look in your neighbor's bowl to make sure they have enough. And this goes against everything I believe in and everything that I was raised, and I am deeply ashamed that my country would do this to people in their times of need. So, I don't know what you do. I asked my wife to research charities. Hank Green put some charities too. I'm going to specifically try to send my money to the Lehigh Valley where I used to live. I think I can figure out how to help people back where I came from. This is unbelievable that we're here. Like I said, I'm a lawyer, licensed, insured, practicing for 14 years now. I've been practicing for 14 years as of October 20th. I've seen 2,000 actual clients that have hired me, and I have seen a whole spectrum of people of different levels of wealth. People who have nothing and people who have more than you could have ever imagined. And I can tell you that there is nothing humane about rewarding someone for having everything and taking from someone who has nothing. It's quite the opposite. For a very small amount of money compared to the benefit, you tax and you spend. You tax the people who can afford it. In our case, we do it based on income and capital gains. And then we spend some of that money to make sure that everybody's got a couple things that are really important. Healthcare is one of them, because a healthy citizenry is a productive citizenry. Oh, well, someone might get healthcare who doesn't deserve it. Oh, screw off. Lots of people are currently getting things they don't deserve. And food for people who need food. Take a look at Maslow's hierarchy of needs. When people don't have their basic needs met, basic security, food, shelter, water, socialization, etc., purpose, they lose hope, and it starts to get bad. It's worse. You spiral down. Mental health conditions, physical health conditions, they become a burden on society, etc. The things you don't want. You give them this tiny bit of help, though, and they don't become as much of a burden, and they even get out of it. Anyway, that's all I have for you today. I will keep an eye on this and keep you updated and try to update this story. But let me know what you think in the comments below. When I post this video, I'll post something about a link to donate to what I think is the appropriate charity. Probably a similar charity to the one Hank Green proposes. But I just have to do my own research. So anyway, that's the sad state of affairs that we have right now. Let's get ourselves out of this by getting rid of the problem that's causing this. Anyway, let's figure out how to solve this one together. I don't know. I can't fix everything, but I want to figure out how to contribute to the fixing of this one. Let me know your thoughts in the comments below. I love you all.